Losing a loved one is undeniably one of life's most challenging experiences. While you are trying to grieve and honor their memory, the last thing you need is the overwhelming stress of navigating a complex legal system. Yet, many families find themselves trapped in the confusing maze of traditional probate, but there might be an easier way. Today, we will guide you through small estate affidavits and simplified probate, showing you a faster, less burdensome path to settling an estate. To understand why small estate affidavits are so valuable, we first need to look at traditional probate and why it strikes fear into the hearts of so many grieving families. Probate is the formal court process used to validate a will, settle debts, and distribute a deceased person's assets. While the concept sounds simple, the reality is deeply bureaucratic. During formal probate, all financial details become a matter of public record. It is also notoriously expensive, with attorney fees and court costs draining a significant percentage of the estate's value. Perhaps the most frustrating aspect is the timeline. Between mandatory waiting periods for creditors and crowded court dockets, distributing assets routinely drags on for months or even multiple years, freezing families out of the financial support they desperately need. If you are overwhelmed by probate, take a deep breath. There is a way to bypass this confusing maze. Enter the small estate affidavit and simplified probate. These are streamlined, state-specific legal procedures designed to help families transfer assets from a small estate without full court involvement. Instead of months or even years of waiting, these tools provide a direct, expedited route to settling your loved one's affairs. Think of a small estate affidavit as a sworn statement. You are formally declaring to a bank or a government agency that the estate meets your state's size limits and that you are the rightful heir. By filling out this document, having it notarized, and presenting it alongside a death certificate, you can claim bank accounts or vehicles directly. Simplified probate works similarly, involving the court just enough to bless the asset transfer, without dragging you through formal, drawn-out hearings. When you compare it to traditional probate, the difference is night and day. It completely cuts out mandatory waiting periods, creditor notifications, and complex accounting reports. Ultimately, the goal of these simplified procedures is to lift the administrative burden off your shoulders. They save time, significantly reduce attorney fees, and most importantly, they help make an incredibly difficult time just a little bit easier for you and your family. So, who actually qualifies to use a small estate affidavit? The answer depends entirely on where you live. Every state sets its own dollar limit to define what exactly constitutes a small estate. For example, in California, the limit is set at $184,500, while in Texas, the threshold is $75,000. To determine your eligibility, you need to calculate the total value of the deceased person's estate and compare it against your state's limit. But here is the good news. You rarely have to count every single item. States often allow you to exclude certain assets from this calculation. Small estate affidavits are typically used for personal property, like bank accounts, vehicles, and personal belongings. In many jurisdictions, real estate is entirely excluded from the small estate value limit. Furthermore, assets with designated beneficiaries, such as life insurance policies or retirement accounts, bypass probate anyway and do not count toward your total. Because the rules for dollar caps and excluded property vary wildly, it is critical to carefully review the specific laws of the state where the deceased person resided. Verifying these local eligibility criteria up front will save you from major legal headaches, save you valuable time, and ensure a smooth transfer of assets to the rightful heirs. Let's walk through the step-by-step process of using a small estate affidavit. Step 1. Gather your documents. You will need the original death certificate, the will, if one exists, and comprehensive records of all assets and debts, like bank statements and vehicle titles. Step 2. Fill out the affidavit. You can usually find your state-specific form online or at the local probate court. Be meticulous. Accurately list all assets, their exact values, and all known heirs to avoid any processing delays. Step 3. Notarization. This is a sworn legal document, so you must sign it under oath in front of a notary public. They will verify your identity and apply their official seal. Do not sign it beforehand. Step 4. Filing. Depending on your state, you'll either present the notarized affidavit directly to the institutions holding the assets or file it with the local probate court. Keep in mind, there is often a mandatory waiting period of 30 to 90 days after the death. Step 5. Distributing the assets. Once accepted, present the affidavit to banks or the DMV to transfer the assets. After settling any outstanding estate debts, distribute the remaining assets to the rightful heirs, completing the simple asset transfer process. While a small estate affidavit might sound like the perfect solution, it is important to weigh both the benefits and limitations. On the plus side, the advantages are incredibly clear: speed, reduced cost, and simplicity. Instead of waiting months or even years in a traditional probate court, you can settle matters in a fraction of the time. Plus, you save a significant amount of money on attorney and court fees. However, this simplified process is not right for everyone. The most rigid limitation is the strict asset value cap. If the estate's total value exceeds your state-specific limit, you cannot use it. Additionally, in most states, real estate cannot be transferred using a small estate affidavit. A house or land will almost always force you into standard probate. Finally, this process is completely unsuitable for complex estates. If the deceased had complicated debts, or if there are disputes among family members about who inherits what, the affidavit will not work. It is ultimately designed only for straightforward, agreeable, and small-scale asset transfers. Let us look at a real-life example. Meet Grandma Susan. When she passed away, she left behind a modest bank account, a used car, and a few personal belongings. Because the total value was well below her state's small estate limit, her grandson John avoided a long and expensive probate process. Instead, John downloaded a small estate affidavit, filled it out, and had it notarized. By presenting it to the bank and the DMV, he quickly accessed the funds and transferred the car title, distributing the assets exactly as Susan wished. While small estate affidavits are designed to be straightforward, they aren't the perfect solution for every situation. Certain complexities warrant professional legal advice. For instance, if you're unsure whether the estate exceeds your state's limit, an attorney can help you calculate the assets correctly. You should also seek help if there are multiple heirs with disagreements, or if the deceased left behind significant debts. Navigating creditor claims or family disputes can be tricky. Don't hesitate to consult an estate planning attorney or probate professional. A little expert advice now can save you a lot of headache later. Thank you for watching our guide on small estate affidavits and simplified probate. Dealing with loss is never easy, but we hope this information helps make the process a little less stressful. Remember, planning ahead and understanding your options is crucial. For more resources, detailed guides, and support during this difficult time, visit funeralus.com. We are here to help you navigate these next steps. If you found this helpful, please like, subscribe, and leave a comment. Take care.